I expect the judiciary starting 2024 to start reasserting itself in some ways.
What makes the system so slow? Why do cases take so long?
TY Chandrachud saying he's never faced political pressure from any government in his 24 years long term as a judge.
I often think of our mythology is so liberal, right? Like we had is it Mohini, Lord Vishnu turns into Mohini, and in some ways we sort of need to make this a conservative agenda to go back to our mythology and open our mind, right? Hi, and welcome to episode 21 of the India Dialogue. We're so grateful that you're here. My name is Ruchir. I'm joined, as always, by my co hosts, Manu and Mitali. As you know, Mitali, you may know her from her time at CNBC. She's about to be acting director at the Reuters Institute at Oxford. Manu runs his own law practice. He's an advocate and a spokesperson for DMK. I am the CEO at Distributed Energy and chair at the School of Policy and Governance. We do this podcast because we care about India. We want to unpack issues that matter in current affairs. Most of our coverage or our analysis so far has focused on elections. We wanted to do something different in today's episode. In a lot of our episodes so far, we've brought up some issues that we want to go deeper on, and we thought, why not take one of those issues today and unpack? So we want to spend most of our time today on India's judiciary and how can we improve the legal justice system in India. Manu, obviously, our resident lawyer who's been so helpful through the past episodes, unpacking complexities in the and helping us navigate the India legal system, will help us. Will talk about how the judicial system is structured and why are there problems that exist in this system. I will open with a simple question, Manu, because I think that's where we should start. What is the structure of the Indian judiciary? So what are the different courts and what are the different justices? How is it organized?
I think it's a great opportunity for us to really understand not only the structure but also the substance of the judicial system in India. Of course, structure-wise, you can think of it as a simple three-tier system. You have your district courts, which is where the trials happen, which is where the first courts of first instance for many cases, where many cases see a full-fledged sort of inquiry or trial which results in a conviction or an acquittal. Then you have what is called the high courts, which is the highest court in the state. Interestingly, in Australia, the high court is like the highest court in the land. So why high courts to talk about highest court in the state? Probably because you only had three high courts in the very beginning, which is Bombay, Madras, Calcutta, the three presidencies. And at that time, they were the three highest courts, and no, there was no other court higher than them within British India. You had to go to what is called the Privy Council. I'll come to that a little bit later. But today we have the highest court in the land, the Supreme Court of India, which is in New Delhi. Now, before the Supreme Court was formed in 1950, by virtue of the Constitution. Before that, for 15 years, between 1934 and 1949, we had something called the Federal Court of India, which was sort of like a predecessor to the Supreme Court. And before that, before 1934, we had, as I said, no court higher than the high courts. And so any appeal from the high courts of Bombay, Madras, and Calcutta, as they were known then, had to go to the Privy Council in the United Kingdom. So what I'm trying to tell you is we actually share more than just a colonial sort of history, right? The entire legacy of the judicial system, what is today called the common law system, which binds India, Canada, Australia, South Africa, Kenya, Sri Lanka, Bangladesh, Pakistan, with the United Kingdom, is because of this structure, as you asked, Ruchir. The structure meant that we all derived our legal practice, our legal principles, and legal procedures from the British, from their understanding of the law. To understand the British understanding of the law, you will need to go all the way back, almost 800 years, to understand Magna Carta and how it moved from the rule of men or rule of kings to the rule of law. But that's probably something which we don't want to get into today, the history of the law. But I'll come back to from the structure to the real substance, right? One of the key aspects in the constitution is Article 50, which says uh, the judiciary must be independent of the government. Though we always talk about different branches of government, we say the executive, legislative, and all of that, but really the branch that is most independent or most farthest away from the executive and the legislature is the judiciary. And this is actually specifically pointed out in the constitution. Now, I just want to add one possible sort of point to sort of take this conversation forward, which is that for a while, after Indian independence, after the Supreme Court was formed, even the appointment of judges to the High Court and the Supreme Court was done directly by the governments. So the union government had a great deal of influence and say in the appointments of Supreme Court judges, and the state governments had a say in the appointment of High Court judges. Now, all of this started changing roughly in the 80s. To be very specific, in the late 70s, when one particular judge, his name is Justice H.R. Khanna, he was overlooked for his promotion to be the Chief Justice of India. So he's the most well-known judge number two of the Supreme Court. Even today, if you go to court number two in the Supreme Court, you will see a big portrait of Justice H.R. Khanna. Now, why was he overlooked? That's a matter of great political interest, but he gave a judgment which went against the then government, the powerful government of the Congress then led by Mrs. Indira Gandhi. So he was overlooked, and essentially a judge lower in hierarchy was superseded him. So this happened at a time when, of course, the executive was very powerful and the judiciary wasn't. Now, things change as they do in any country and in any society. And when the government or governments successively became weaker or less stronger, the judiciary started asserting itself, and it came up with this concept called the collegium, which is not written anywhere in the Indian constitution. It was not discussed anywhere by the framers of the constitution. So they came up with the concept collegium, where they said, no, we judges will appoint our successors, right? And this was finally given sort of the judicial imprimatur in the early 90s. Again, I want to make this point because I want to sort of come back to this later, which is that when the executive was not at its strongest, when you had probably for the first or one of the first few times a non-Gandhi, non-Nehru Gandhi as the prime minister under P.V. Narasimha Rao, at that point of time, the Supreme Court finally asserted itself and said, it's called the third judge's case, and it said that we will now only the Supreme Court judges will decide who will now next be who will be the next Supreme Court judge. So that, they said, is part of this independence of judiciary from the executive, which is written down in Article 50. Now, I want to make this point very clearly because from 2014 to 2023, I think most of us agree that the executive became much stronger, much more assertive, and judiciary became, I would say, less assertive, and perhaps in many cases not being the real sort of counterforce to the executive. But as many people have pointed out, the 2024 elections were put out a lot of surprises, and the first and foremost amongst them is that we have probably the strongest opposition. So you have 234, which by logical extension means you have a government for the first time which is not as strong. So I expect the judiciary starting 2024 to start reasserting itself in some ways. But like I said, We will come back to that, but I just wanted to give you also like a flow of how things have happened between the executive and the judiciary. And it's important to remember that, because judiciary doesn't exist in a vacuum. Often it is reviewing decisions made by the government. Often it is deciding on bail petitions on politically sensitive matters where the government has a huge stake. Often it is deciding the constitutionality of laws passed by the parliament. So that is why I wanted to make that larger point around the judiciary.
And because we've talked about this a lot in terms of people's first touch point is actually municipal issues. So where in
Mhm.
the chain would you place village courts or lok adalats, in the hierarchy of things? How much credence, I suppose, do they have? And the second is on this point about being independent from the government. How is that ensured down the chain? Like, how is that ensured that it is maintained and respected at a high court level and then at a district court level, which is where the ordinary citizen would probably have more touch points.
Very, 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 I think, very fair question. I'll start from the Lok Adalat question because that's more straightforward. Lok Adalats are sort of mediation centers. They are manned by retired judicial officers, or sometimes even retired government officials. They are when, there's long-standing disputes which are pending in court, and the court says sometimes, do you want to go and try to mediate this out of court and come? And then they go to the Lok Adalat, which usually sits on a Saturday or a Sunday once every 2-3 weeks. And often the high courts and even the other tribunals, they push a lot of these cases to Lok Adalat just to see if the two parties would come and sit and talk and give some sort of closure to it. And if that happens, then that mediation award or the mediation decision is sort of given that seal of credence, or it's given an imprimatur by the high court or the tribunal. So they are quite successful in drafting or crafting out of court settlements, which are very useful, right? There are some cases which can just go on for too long and people have lost sight of the whole issue, but or they've moved down and they just need some closure, so on and so forth. That's that's how those courts have functioned, and they've done quite well. Though people still, sometimes come and tell me that no, but it's the principle, it's not the money. So I want to fight this. Doesn't matter how much more money I spend in lawyer fees. I want to keep seeing this to the end. So that's a different ball game. Now, with regard to ensuring independence in judiciary, so you have to go right to the bottom. So the district courts, they have judges are appointed through a competitive exam called the civil judges exam or the district judges exam. So they, there it's a test, right? So they write the exams, and then there's an interview, and then they get appointed. Now, in most high courts, and I know this very well in the Madras High Court, but in most high courts, what happens is, for out of every three judges who are made high court judges, two of them come from the legal fraternity. So they are practicing lawyers with at least 10 years experience in the field, and one from the district judiciary gets elevated. Now, from there to the Supreme Court, there is no such ratio followed. But in the last 10-15 years, we've been seeing a lot more lawyers being elevated directly as Supreme Court judges. So the most recent was Justice K.V. Vishwanathan. Before that, Justice U.U. Lalit, Justice Rohinton Nariman, Justice Nageshwar Rao. There's a few in the last few years. And in this specifically, Justice Lalit became the Chief Justice of India, and Justice K.V. Vishwanathan will also end his tenure as Chief Justice of India. So some practicing lawyers get to go, but that is a rarity. Most 90+% of the Supreme Court judges come from the High Court stable, from the different High Courts. Those who are at the highest, at the peak of the High Court, they're usually the Chief Justices of that High Court. Now, there is a problem with this whole independence issue, and I'll briefly touch it because I told you a little bit about the appointment procedure through the collegium. Now, the collegium is a group of judges. Usually it is 3 or 5 depending on the court, sit together and they decide whom to now appoint as the judge, right? But they rely on quite strongly an intelligence report from the government. So if it's a high court, the state government; if it's a union, if it's a Supreme Court, the union government. And that's where the government can really play some mischief, right? Because they have files on everyone, but it is which files they want to sort of put. So you see some judges, and some judge candidates, even after the collegium has recommended their name, the government has either done two things: one, given negative adverse remarks against that judge, okay, and these adverse remarks sometimes are funny and frivolous. They say things like, he once put up a Facebook post criticizing the government, or once did some something quite ridiculous. Or alternatively, even after the collegium is recommended, and this is where the government holds the last sort of final hold on it, which is that the president has to issue a warrant. That's like an appointment letter, right? So we have instance of one particular person from the Madras legal fraternity, who was, the collegium has recommended his name to the union government, but for 4 or 5 years now, the president has not signed the warrant. So what's happened is, now after a point, so people lose interest. Anybody who wants to become a high court judge, it's usually around the age of 50. But once you hit 55, you only have 7 years left. So you retire at 62 from the high court. So they lose interest after 55, 56. So the government can play absolute havoc if they want to, and stop. This is the union government, because the president will act only on the advice of the home ministry. So unless home ministry clears the file, that will not happen. So ensuring independence right to the bottom happens quite naturally, because it's through a competitive exam. The government has very little say in it, of course, unless you influence the process in some unlawful way. But around the high court, once they come to the high court level, the government does have a say. They can give intelligence reports against a person, or suppress a report in favor of somebody they want, right? So they can do both. Ruchir, you were going to ask something?
No, but I like that thread is not relevant. The thread I want to focus on is the speed piece, especially. I mean, I think this is perhaps at least the complaint I encounter the most, which is one of backlog and efficiency. What makes the system so slow? Why do cases take so long?
So typically, there's two issues. One is at the point of entry, right? What we call access to judiciary. So India has one of the lowest costs for filing a case. So typically, to file a criminal, any case on the criminal side, you're paying court fees of a few hundred rupees. To file a writ petition, so in against challenging an order of the government, it's 1,000 rupees. Now, you only have to start paying big money, and I'm saying big money in relative terms, when you file a civil suit, right? So, for example, this also changes from state to state, but I'll tell you Madras High Court or Tamil Nadu, where if I want to sue somebody for 100 crores, then I have to pay 3% as court fees towards. So why is this done? So that you can stop people from coming up with ridiculous numbers, right? 10,000 and 700 crores and things like that. So people do. So that's why most suits for defamation in the Madras High Court are 1 crore, 2 crore, which means they pay about 3 to 6 lakhs for court fees. Now, for every other case, it's literally hundreds of rupees, if not a couple of thousand rupees. So a lot of people do have access to filing a case. Once they file a case, the second problem is that it's like a chicken and egg situation. The courts are already backlogged, so the cases join that backlog. And because these cases have joined, there's more backlog created, and that takes more time. Now, this is where the culture of legal advocacy is, I think, to be blamed, and that involves lawyers and judges in the court system, which is that there's a lot of adjournments that are sought. Tomorrow I have a case, so I'm not ready. I'll go and tell, can I please, argue this matter next week or 2 weeks hence, and that's usually allowed. Whereas in the UK, for example, a very strict timeline is fixed at the start of every case, and the lawyers on both sides have to adhere to that. So that's one part. So where people start, kicking the can down the road, and partly the judiciary must take some blame for this, because they enable it, they allow it, they permit it, and also in many cases, I see the judiciary not taking a call immediately, right? something where we've been told, the cases should not take much time to decide is a application for bail or anticipatory bail, because it deals with a person's liberty. I want to go back to last week when I was just reading a decision in the Delhi High Court where, interestingly, Arvind Kejriwal, we've discussed Arvind Kejriwal's, I think, arrest and bail petitions for about 3 or 4 episodes now, but this one is relevant. He was granted bail by a Delhi district court. Immediately, the enforcement directorate challenged that bail petition and came to the Delhi High Court and said he's been given bail, don't let him out, right? So they are challenged. That's permissible, that's allowed. And the Delhi High Court, to its credit, took the case up immediately and heard it. But where I disagree with the rest of what happened is the Delhi High Court then said, oh, we will reserve orders, which means we will go and consider this, and it will take us 2 to 3 days to give the final order, decide the outcome. But until then, we will stay the bail order that was granted by the lower court. So again, there is no reason. Bail is very simple. It's called a discretionary power. The court can give or not give based on very few conditions. There's no great deal of law involved. But for a high court which hears bail petitions routinely and often, in the Madras High Court, on an average day, around 200 to 250 bail petitions are decided, right? There's no reason one bail petition should be had for 3 days or 4 days. So I do think that the courts have been particularly remiss in deciding, in determining and giving outcomes quickly where they can. Of course, there are matters of great complexity, legal complexity, constitutional difficulty, which require a lot more time. But even then, if you see the number of constitutional issues, I think we touched about this as well, and I think everybody knows. For example, Article 370, right? It took almost 5 years for that case to be heard. The case of electoral bonds took about, I think, even longer, maybe 6 or 7 years, and after that they said these are bad in law. So we could have avoided a lot of, we could have avoided roughly 12 or 15,000 crores of money being put in electoral bonds, right, had this been heard. In direct contrast, when there was a question during Boris Johnson's prime ministership, he prorogued Parliament early. This whether he had the ability and power and competence to do that went up to the UK Supreme Court and went through 3 levels in the court system there in the UK within 3 months. Right. So here, what takes us about 6 years for the Supreme Court to decide was decided. And why that's important is it gives quick resolution. People are not wondering for 5 years. Like we didn't have a whole government, move. And I'll make the last point, which is again very interesting in the present times, because we've just had a new parliament, a new government, and very recently we've had a new speaker being elected. Right now, the speaker has a very important role. Of course, the speaker is the head of the house, the chair of the house, and all of that. But the speaker is the only person who can disqualify a member of parliament under the 10th schedule for defection. Now, typically, what is defection? So people get into parliament or a house, on a particular party, and then once they're in, they change party. So this has happened now in Telangana. We have people moving from the BRS to the Congress in the last week or so. Now, what happened is the speaker there'll be a petition that'll be filed before the speaker, and the speaker will be called upon to adjudicate whether this person has defected and therefore should be disqualified. But often, and we've seen this repeatedly over the last 15-20 years, speakers have sat on these petitions for 5 years. So the entire parliament, the tenure is over until it gets decided. This is what I'm trying to say is, it's very similar. Like, this is how courts are deciding. This is how speakers, when they act as courts, are deciding, and so on, which I think is partly the cause for the backlog. There could be one, because I think we started this show saying that we should also suggest solutions. So this is one. There's so much work that can be now done. The Odisha High Court has started using artificial intelligence to write down some orders, right? A lot of the order is just padding.
Yeah.
And the decision part is very little. And this so they're using it, in the right way. There's virtual conferences, right? During the COVID years, we moved a lot of the hearings to virtual, and now we're getting, lazy or non-lazy the other way, which is, everybody wants to come back to the courts. But I think it would be efficient if we sort of went back to virtual. So what I'm trying to say is, Ruchir, this is your area, so you need to step in here. We can use technology to really reduce a lot of the backlog, a lot of the pendency. I don't know why we do. I don't know why we don't do it. I don't know why we don't just come up with a better, what I would call a case management system, where it's very clear which date the case is coming, and we agree that there will be no adjournments. And this is what happens in other Western jurisdictions. If you ask for time, then there is a cost to it, because I've come prepared, Ruchir is not prepared, and Ruchir is asking for time, so he pays some cost, right? So it should be a disincentive. Why we don't do all of this, I don't know. But like many things in our country, I think it takes a while to change, to evolve.
Sorry, I have two related questions on the same point. One, does money solve this problem? So you said, um, we charge very little for some of the filings. Does filing more help sort of remove a lot of stuff that is not serious and also gives money to the courts? And the second is on the courts. Obviously courts are adjudicating on the basis of law, but who decides how the courts function? Is it just the bench of Supreme Court justices, or is there an administrative division that's thinking about all of this?
I'll attack the second question first, because I think, again, it's one of the lesser known aspects of the judiciary. So the judges have two functions: judicial and administrative, right? All you see in the newspapers when you hear about this judgment being given, that bail being denied, this case being quashed, that is what is called judicial functions, which is that what they do when they sit in court, literally, right? So when they don't sit in court, they do something in their chambers, which is still part of their job, but that is administrative. So, for example, um, the Chief Justice of the Madras High Court decides which judge hears which category of cases, who hears the civil cases, who hears the criminal cases, and so on. The Chief Justice also decides, again, which judge sits in the Madurai bench, who sits in the Chennai bench. They also decide, aspects about administration. So it's the judges ultimately, but more specifically, Ruchir, it's the Chief Justice of each of those courts who decides administratively, or can I say, how justice is administered in that jurisdiction, right? Now, coming back to the money issue, it's very interesting. Obviously, you have to sort of strike a balance. You don't want to make it prohibitively expensive that people cannot access courts, especially poor people, poor litigants. But at the same time, it's so cheap that anybody can file a case and keep it running for a while, right? um, I think there's two ways to look at it. One, I do think certainly increasing costs would help, because people will then be more smarter about filing cases. So I'll tell you why. So in jurisdictions like Australia, this is allowed. So if you go with a medical negligence claim to a lawyer, the lawyer will say, I will do it on a no win, no fee basis. So if we win $100,000, then you give me my 20% or 30, whatever you decide, right? But if I don't, it's no fee, right? So it's good for the litigant, because costs are prohibitively expensive there. But we do not follow that system. So therefore, for us, we can't do what is called a contingency fees or a no win, no fee basis. But if you move to that model, you can have a higher fee, higher court fee model, and reduce the number of people coming into court. So why I'm saying that is, in a country like Australia, before actually lodging a case or lodging a claim, the lawyers spend a lot of time in assessing whether they want to take it up, whether it makes sense, because ultimately the lawyer is absorbing a lot of that risk, right? It's not just the client. The lawyer has to see whether, if the case doesn't do well, then they will not get paid for whatever 3 6 months, 8 months of their time. So that is one idea. And the other idea is, of course, to push of more out of court settlements, right? Which is something we don't do enough. Like, why is everybody going to court? There are things, where you must say, look, this is something that is your fine amount is 75,000 rupees. If you litigate this over 6 months, it'll probably cost you 2 lakhs. What do you want to do? Like, don't you want to just pay the fine and be done with it, right? And that's a conversation which in a sense is anti it goes against the interest of a lawyer. When I can bill 2 lakhs in 6 months, why am I why am I being the voice of reason here? So again, but that's the sort of thing that needs to be done. We must have a ethical responsibility to advise our clients of these costs, because
Yeah.
they get into it, and 6 9 months later they are wondering why they're in it, and they get stuck, and there's no way they can get out of that case.
It's a good segue to what was on my mind, Manu, which is probably which may not have ready solutions, but there was a comment recently by the Chief Justice of India, D.Y. Chandrachud, saying he's never faced political pressure from any government in his 24 years long term as a judge. Uh, are there firewalls in place in terms of political pressure and or corruption? Because that is the other general refrain, right? One is pendency of cases, which is that I just don't, my case doesn't even get heard. The other is this literal fear that the judge is sold out or the judge is compromised. Are there firewalls to that, and are they sort of example, or is it that this is a global phenomenon or a problem that other countries face as well?
I don't know about too many other systems internationally speaking, but in the Indian system, like I said, we briefly touched upon the appointment process, and the government can have a role in who gets through to the bench. More importantly, who doesn't get through, and because of that government ability to shape that decision, the judges do feel. I think the judiciary does feel sort of. Having a good relationship with the government is important, and when they start off, the second part is during the time a person is a judge of the High Court or the Supreme Court, their tenure is so secure, right? It is almost impossible to impeach a judge. We've come close on, I think, two occasions, and both occasions Parliament did not go through. And I don't think anybody in their right mind would agree or argue that the judiciary is free of corruption in that sense. So, but why has no judge ever been impeached in that sense? It's just because somewhere they strike some balance, or strike some deal, or they retire or whatever. But my point is this: it is impossible to impeach a judge. So during the tenure of a judge of a high court or supreme court, the system provides that protection, right? You're not going to get removed by the government tomorrow, but next year. It's not at all easy. The judiciary as a fraternity is also quite protective of its own. So they will not allow any high court judge or a supreme court judge, because that casts a big sort of shadow over the entire system. So that is that. But this is, I think, what is now becoming a huge problem: post retirement sinecures, as Arun Jaitley famously called it in parliament, right? Now, so many of the big committees, councils, then we spoke about the National Human Rights Commission, many other, like the Press Council of India, so many. It specifically says in the law, and Parliament has enabled this. It says that this has to be headed by a retired judge of the Supreme Court, a retired judge of the High Court, and so on. So a lot of them, it pays, right, literally, to be good to a government in your last few years, to be in consideration. Of course, if you're somebody who's super critical of the government, there's a good chance you won't get it, right? Now, we've also seen another disturbing trend. We've seen retired judges of the Supreme Court be appointed as governors. So Justice Sadasivam became governor of Kerala. Justice Nazir is now the governor of Telangana or Andhra. Sorry. So one of the two. So again, this is again very, very, I think it shows a great sort of, I think, the start of blurring of lines, because as governor, you essentially report to the president, who's advised by the union home ministry. Whereas in your capacity as a Supreme Court judge, you could summon the union home secretary to come to court and answer any question you had, right? So from a position of where you could summon the home minister if you wanted to say what is happening with this inquiry, what is happening in Manipur. I wish we heard that, in our courts, so in our court halls, but we didn't. But we could do that, to then becoming a governor who essentially is a nominal ceremonial figure under the aegis of the president, but indirectly sort of, under the uh, supervisory or under the effective control of the Union Home Ministry, right? I don't have a problem with that. I think governors should be under the control of the government, right? But the question is, a retired judges becoming, in actively involving in such constitutional roles is a cause of concern. So there is no firewall. So a lot of people have advocated, and again we're coming back to the suggestions part here. A lot of people have said there should be a cooling off period. You finish as a Supreme Court judge for 5 years, you cannot take a government role, huh? And that's fine. You finish at 65. Bear in mind, in the United States, you're a judge, you're a Supreme Court judge till you die, right? So here 65 is still fairly young. They have another 15 years at least, I would say, of active public service should they choose to. So you're only taking 5 years out of that, right? So I think that's something that needs to be considered. Maybe like reducing these post-retirement opportunities for judges. These are areas where they could, I think, come into interface with governments, and there could be expectation that I'm a judge today. I'm doing something good for you. Tomorrow, will you help me? Will you put me in a place where I could? Of course, there's a famous case of Chief Justice Ranjan Gogoi, who then became a member of parliament, right? Of course, he was it was through the president nomination, but still, I think, so we are like, in the last 10-15 years we've broken very interesting ground for judges after retirement.
Manu, in the spirit of Pride Month and the fact that you were involved with this case, I want to spend a little bit of time on the um, semi-famous LGBTQ case out of Madras High Court. One of the most striking things I remember about the case was the justice said, "Hey, I need more time to understand LGBTQ, their rights, what are the physical aspects to it, and so on." Like that really blew my mind in terms of judges reflecting on their own biases and conditioning and training. I'm curious, maybe give a little bit more context about the case to begin with, but then I want you to build on that and help us understand also about how do judges grow as people. Do they think a lot about their responsibility, or is it about let's go to the next court?
No, I think, I mean, firstly, that was a particularly challenging case, I think, for everyone involved. But to answer your question, like generically, judges do think about, I think, a lot of what it is that they're saying, right? Because now everything is reported so well. There are great websites, Live Law, Bar and Bench, which report almost contemporaneously as the on court proceedings. So there's a lot of reportage, and that's great. And I think, sunlight is the best sort of disinfectant, as they say. So once you make everything very transparent, it also makes sure that judges think about what they want to say, what they say as observations in court, and so on and so forth. I think a lot of judges do think about it, but I don't know. I don't know of any other judge, like in this case, who had sort of reflected upon what he called it his own personal prejudices or biases. He said he took a moment to reflect upon. He said his own prejudice, and he said he wanted to understand that. Though he called it, he wanted to undergo counseling. I requested him to call it psycho education or psychological sort of education, understanding, something better, but sitting with a person who's a queer affirmative therapist. The case actually, Ruchir, began when, it was referred by a colleague from Delhi, Chennai, asking, if I could sort of represent or just meet with these two young women who are going through some difficulty. So when I did, it was an interesting experience for me. I found it. I was amazed, because we had just come, out of about, it was 3.5 years ago that, or 3 years ago, that the Supreme Court had decided on the constitutionality of Section 377. So, where it said it decriminalized homosexual relations essentially. But a lot of the petitioners in that case were like very big famous people, right? And often, that gave a lot of fodder for people who wanted to be critical of their judgment, to say, oh, this is such a elite issue, this is not what common people go through, and so on and so forth. So when I met these two women, they were so they were just like anybody else. They were, two people who wanted to be together. What struck me was, they were both from very economically weaker background, very poor. One of their fathers was a watchman in an apartment. Um, and they'd just come from Madurai, which again was very interesting to me. Madurai is my hometown, my parents' hometown, but it's a city around 400 kilometers further south of Chennai. So it's not even Chennai. Chennai is not the most cosmopolitan of Indian cities, but nevertheless, it is from, I mean, Tamil Nadu, which is not Chennai. So I found it very interesting. And the last thing was, they were at that time 20 and 22, if I recall correctly. And just for young people to say, take a stand against their parents, against society, to leave their home and come to Chennai and try to find a living and whatnot. They felt they were being constantly watched or followed or something. So we spoke, and then we decided to file something called a police protection petition. I often joke to people, it's sometimes what we need is protection from the police itself, right? Because police are the first moral policers in our society. They are the ones, they'll say, how dare you, how could you do this to your parents, and all of that. So nevertheless, we filed a police protection just to sort of say we wanted to bring this to the attention of the court. The challenge I had was this: now police protection orders are given quite frequently in high courts for intercaste or interreligious married couples, right? So against the love jihad vigilantism. Now that was understandable, and a lot of judges were also, I think, understanding of protecting couples who are married but against the wishes of society and parents, right? But here I had to explain to the judge, no, this is not a married couple. Oh, also, by the way, this is not a heterosexual couple. It's not a man and a woman. So it meant us explaining that, but we drew the logic from intercaste marriages and the protection that they get, right? The judge was very accommodative, immediately ordered police protection. And then when I started explaining what this case is, said, oh, this is a very interesting case. I don't know if there's a similar order that is being given, so why don't we do this better? I argued one thing. I mean, I have to be open about this, which is that I said, look, it is not our intention to separate them from their parents or anything. Though they're adults, they do what they want. I understand the parents also have a concern, right? And at some point, they may reconcile. They may not, they may want to, but it's not that we want to like say we'll never get in touch with the parents, and we are happy to let the parents know. But partly it is also helping the parents understand that this is okay. I told you the women were from a poor background, from like a rural Tamil Nadu background. But imagine their parents, right? Add another 30 years to that. So one of the first things we did was we got the parents to undergo counseling on queer issues and whatnot, which was I think that was the one of the best orders we could get, because it made, we were able to convince the court that the parents also need support, right? We don't blame them. Of course, they are upset, they're angry about their children, but maybe that is their social conditioning, right? They don't know any better. So we wanted to take them through that. We helped the women also go see a therapist to help talk about their own trauma, because they'd spent about years of not coming out of the closet, and then finally when they did, years of sort of repression and opposition from parents, non-acceptance from the parents, and so on. So we got that done, and then slowly then the judge came around, wanted to undergo psychoeducation. So to answer your question, Ruchir, it's not often this has been done, but I do think judges do think about the larger effect their orders have on society, and they want to now, I think, modernize their thinking. They want to sort of be in sync with what's happening in society at large. But the last point I wanted to make, and maybe sort of throw this back to you guys also, is so last year we were very hopeful about the marriage equality case. Many people who are following it, thought that this was India's moment to sort of lead the marriage equality sort of trajectory, and show the world how a country like India, traditional, always thought to be conservative, had broke from the shackles and so on. But two things happened initially. Though the court was very positive and open, the union government put a lot of pressure on the court to first restrict everything only to the Special Marriage Act. Though there was Hindu Marriage Act and the other marriages, they said no, no, only restrict to Special Marriage Act. And once that was done, they also opposed this on many many grounds, and ultimately the verdict was that homosexual couples have a right to relationship, to be in a relationship, but not to marry, because marriage is something created by statute. So if you marry in India, you have to register under either Hindu Marriage Act or Special Marriage Act, or if you're an Indian who married overseas, under the Foreign Marriage Act, so on. So it said that because these acts specifically said man and woman, we cannot now interpret it to be a woman and a woman or a man and a man, right? So it was very disappointing in that sense. But I know the two of you would have followed it. So do you have any sort of thoughts on how this case went, and maybe what you heard and read about it?
I actually know two of the people who were involved in that case, Dr. Kavita and Ankita,
Hmm.
who have done, I mean, incredible work with children. Dr. Kavita is easily one of the country's best
Yeah.
child psychologists. Ankita has done so much great work in art therapy with children. So first of all, just as individuals and human beings, they're fantastic people, and I've had some connect with them, and I'm really grateful for that. I I will say that a lot of a lot of these preconceived notions are not unique to India. It's something that in the United States of America, for example, is becoming a pretty sharp political issue between what one candidate, President Trump's stance is, versus what the Biden administration stance has been. So I know it can be quite divisive in nature. I think it would have been an incredible moment for India's legal system to have accepted that and opened up that space, and we would certainly be counted as a progressive, liberal, far thinking nation. Unfortunately, it didn't happen. I think there's also sort of other pockets to it, Manu, because you highlighted the legal aspect so beautifully. Just for example, I wonder how much of India Inc. is thinking about this. Such a large part of the lives of the queer community is spent at work, and I think very little thought is put into what are we doing to make them feel included, what are we doing to ensure that there is no bullying, what are we doing to ensure that there is a mechanism in place where they can raise issues if they feel that they have been discriminated against, or if they feel that they have been mistreated at work. Even something as simple as the Pride Month, which is when we are speaking, it often boils down to members of that community to organize something, at a company level or at a community level. It's not allies coming in from the outside, it's from within that they have to do that. So I think that's, honestly, it really bears reflection for us as a society on how we want to be more inclusive, and this goes across, of course, gender and caste and race and class, and certainly sexual preferences as well. And I'll just say, like, there are so many amazing writers, and Vikram Seth writes really beautifully about it, but it's so at one level it seems so granular and simple. It's sort of like who you choose to love really should not be anyone's choice but yours. And I just feel like if you hold on to that tenet, it's kind of really simple and intuitive at one level, but at another level it becomes so complex, as you point out, Manu, where families and communities come into it. So yeah, that's my thought. Ruchir.
I'm going to add one more question to Ruchir. Ruchir, please build on what Mitali is saying. But so this is Pride Month, and lot of India Inc. Mitali do sort of change their logos or give it a rainbow and all of that, and sometimes they are accused of symbolism or tokenism, or I think the word is slacktivism, but I also think, Ruchir, that it's better than nothing, right? And maybe you start with some tokenism, and then. But what are your personal thoughts and experiences on this?
There's a whole episode to be done on how to run a good campaign, and there are like multiple components to it, including some of like getting companies on board and then people on the ground and then legislative change, etc. Um, I want to, because we've been talking about courts, I want to say two things. One, I want to make a comment and then I have a question. The comment I want to make is I sometimes wonder if this is a hangover from the British era because they are the ones who introduced laws against homosexuality. And because I often think of our mythology is so liberal, right? Like we had is it Mohini? Lord Vishnu turns into Mohini, and then Lord Shiva is attracted. There's obviously the Pandavas marrying one person. There's Shikhandi. There's all of these examples of um, an open mind around a human being's sexual preferences, right? So I feel like we went backwards under the British rule, and in some ways we sort of need to make this a conservative agenda to go back to our mythology and open our mind, right? So that's where I am on the issue itself. But the specific question I had for you is this a case of picking words over intention? Do we have a problem in our courts where we are literal and not focused on the intention of the law? Which and and last question, because I think we can continue so long. So, how do we also address the perception around the courts? Right, I find like so much of the settlement now happens through gundagadi, right? Like people fighting each other, etc. And that often is a reflection of the society that where courts are not reliable, or they won't get the job done, or they will take a long time. So how do we change the public perception as well? They are my last two questions, and I won't ask any more.
Public perception. What was the one before that? Sorry.
Like the what you just said about how the courts around the Marriage Act refer to man and a woman and not a man and a man or a woman and a
Literal.
woman. So is it they took it literally as
Yeah.
opposed to the intention?
Yeah.
So
Yeah. Yeah.
is that our system basically?
See, I think the courts can be extremely interpretative when they want to be. It is called the harmonious construction. They say that when you interpret a word, you have to read it sort of harmoniously with what is in the rest of the sentence, and the section below and the clause above, and so on and so forth. So it is not the literal interpretation, but what they call the pith and substance that needs to be looked into. So they can be very modern and flexible in their interpretation when they want to, Ruchir. Like I said at the earlier part of this conversation, there is no word called collegium. There is no concept of collegium. Nowhere in the constitution does it say that judges should appoint judges. Yet the Supreme Court was very, shall I say, very, very sharp in construing independence of judiciary to mean judges should appoint judges. So when they can do that, they can easily construe man and woman to mean otherwise. In fact, there was one Madras High Court judgment in 2019. It's a case where a trans woman and a man get married in a Hindu temple, and they go and try to get their marriage registered in the Hindu Marriage Act. And the person says, sorry, see, you have a trans woman identity card, you have a man identity card, and same thing. It says man and woman under the Hindu Marriage Act, so I cannot do it. So this is the written sort of rejection given in the registrar's office. Against that, they file a writ petition before the Madurai bench of the Madras High Court. And in that particular case, the Madurai bench, the Madras High Court says you cannot say literally man means man, woman. It says trans woman also means woman can also be interpreted as trans woman, right? So when woman can be interpreted as trans woman, what we are now asking is, can woman be interpreted as man or person, right? Essentially, that is something I think courts have been extremely reluctant to do, only because there is a tremendous amount of pressure. And partly also, I want to touch upon the point about mythology and the Hindu tradition way of living before the British sort of interference, right? It is the present union government which has raised the most strongest objections against marriage equality, or ensuring that this is extended to everyone. If this is a government that sort of went by, as you said, the various instances of Hindu mythology, they would have done other way. And just to make another point, the British, I mean, though we can blame them for a lot of things along with Jawaharlal Nehru, they in their own parliament in 1967 brought the Sexual Offences Act 1967, where they permitted homosexual acts between consulting adults at that point of time. So really, it took us 2018 in Navtej Johar after the Supreme Court did that. So our parliament, still hasn't done that, right? I mean, it's just because the Supreme Court has struck it down. Now, the last question I think was around sort of the credibility of the courts system. Is that right,
Yeah,
Richard?
like public trusting the court to resolve differences, basically.
So I think there is a great deal of trust. I think that is the reason why you have a, what do you say, like a oversubscription of the court process, right? That's why there's so many cases. If they weren't, they wouldn't. And partly, that's because there is a certain majesty of the courts. There is a certain we follow the rule of law, in the country. So people do, I think, by and large accept what courts have said as to be some sort of final truth, or sort of they see the courts as the final arbiters. The problem is, to get the finality of that final decision takes a long time, right? Starting from the district courts up to the Supreme Court, it sometimes takes 20 years, 25 years, and so on. But people do believe in it. I mean, that's why we are flooded with petitions, mercy petitions, petitions to stop hanging, even for terrorists convicted of very serious terrorist crime. People do look to courts, right? I mean, I'll just say one last thing, which is a very interesting case. So there were people who were convicted of assassination of Rajiv Gandhi, right? Seven of them, they were given death sentences. In 2010, they approached the Madras High Court and got the death sentences stayed. In 2014, the Supreme Court commuted the death to life. And in 2019, no, 2021 and 2022, the Supreme Court ordered the release of these convicts, saying that they've already served 30 years, which is the maximum permitted time. I'm just saying this to show that if somebody who has been convicted of a terrorist attack, and somebody, even they believe that the courts will come to their rescue, that there is a rule of law, and the courts, in spite, and there was a lot of opposition. I'm talking about this particular case because there is a lot of opposition of to them, being released. Even in those cases, there are, I think, examples where the courts have resisted popular outrage and have done the right thing, because that's what the law says, right? And the law should be the same for everyone. If it was me being accused of a different crime, having served 30 years, then I should also be allowed to come out just like them. So I think that those principles, I think the fact that the court is the final savior of, even to protect someone from a death sentence, I think people believe that. I think there is still that level of trust and faith in the court system. And I think if you study the judiciary as a brand, I would say, compared to a legislative or the executive, or even maybe the media, and we'll spend another hour grilling Mitali on all things media soon. I think it's one of the best protected brands in that sense, right? I mean, it's a brand with the least amount of, I would say, damage.
Boys, is it time for Have You Heard?
Yes, let's move to have you heard.
Okay, and we will give poor Manu's vocal cords a break where we've like grilled him for an hour. So, Richard, you go first.
Um, I had a menu to pick from, and I picked the one. Of course, everyone's probably heard of it, which is the Julian Assange release.
Ah,
Uh,
Okay.
do you want to do another one, Ruchir? Just asking.
All right. All right. I was going to take the Bitcoin angle of that release. You can take the core story if you want.
Very good.
But,
Let's hear.
the it's a complex flight home for him. And that airplane cost $500,000 because it was not a London to UK flight, a London to Australia flight. It went via the island of Saipan, which is in US control near the Philippines and so on, or near PNG, and that was because there's a federal court. And Manu can explain the legalities, but it was such an expensive cost, and they didn't have the money. They thought they will start the fundraising campaign after, and it got a secret donation of 8 Bitcoin to pay for it, with a tweet from co-founder of Twitter Jack saying "Safe passage home." So
Ooh.
everyone's speculating that the co-founder of Twitter basically gave a donation to help Julian Assange get home. I thought that was interesting. There's a massive community of people who support what he did. That's all. Like, that was the have you heard from me.
Manu, your turn.
Yeah, I mean, I really had not heard of that.
Mhm.
I mean, I heard what I think a lot of other people had, which is that Julian Assange, founder of WikiLeaks, having sort of undergone a lot of, he had undergone a time in asylum in the Ecuadorian embassy in London, and then was in Belmarsh prison, serving 5 years. And interestingly, was a person who was also accused of instigating leaks in 2016 to which helped Trump defeat Hillary Clinton. But then it was the Trump government which then charged him under the Espionage Act, and finally has pleaded guilty. Yeah, the 2 points I wanted to make was very interesting that he was allowed to go to not the US mainland, but the island of, as Ruchir said, in Saipan, which is in the Pacific, almost, to sort of stop there and then move onwards to Canberra. But the larger point I wanted to make is the role of Canberra itself, right? So Julian Assange is an Australian citizen, for those of you who didn't realize that. But until 2022, so when the government finally changed in Australia and they got a Labor government again, Julian Assange was still persona non grata, right? But in 2022, Anthony Albanese became prime minister, and he starts talking about Julian Assange on the floor of the parliament. He says something like, "It's an Australian citizen. How can we allow this? The US administration is our ally, so we must, bring this to a close." And those words sort of, I think in a way re-triggered a lot of diplomatic back channeling, which no and this is the interesting part, right? Both sides of the aisle supported Julian Assange's return. And in fact, the former Deputy Prime Minister Barnaby Joyce, who's as far to the right as you can see in Australia, he supported it, and he raised this when they met the US government for some other diplomatic talks. I want to make one other point here, which is that, of course, it showed a lot of will, and it's I think it always helps if you're a citizen of a Western country. I can't see this happening to a third world country citizen in any other situation. But if you see the two people who led the diplomatic back channeling, they're actually not diplomats. One was the Australian High Commissioner to the UK, and the other is the Australian ambassador to the US. Australian ambassador to the US is Kevin Rudd, former Prime Minister, and the Australian High Commissioner to the UK is Stephen Smith, former Foreign Affairs Minister. So there were two hardcore Labour, dyed in the wool politicians who were leading their diplomatic missions in these two countries, who led the campaign. So I thought that was very interesting angle and twist to this, but definitely the Bitcoin is a is a great one.
Yeah, and I just have a somber twist to the Assange story, which is that, part of it is also that he spent 5 years in almost a maximum prison in the UK. So there was a sense that he had done his time and, paid his dues in a way. But the larger question for journalists, I think, is, has this left a lingering lesson for those who are whistleblowers or those who take on states on the consequences? And it's quite ironic that the day Assange was freed was the day that Ivan Gershkovich, who is a journalist with the Wall Street Journal and has been sort of imprisoned on completely flimsy grounds, goes to trial, which is, it's a closed trial. Nobody knows what he's tried for. There is no evidence, and could potentially be looking at many, many years of jail, if not decades. So quite grim, I think, in terms of the takeaways. But my have you heard is not so grim. It is to do with planes. Have either of you heard of raw dogging a plane?
No.
No, yay. So this is apparently, and I saw someone tweet about it, and I thought, huh, what is that? It's a new TikTok trend where plane passengers are basically boasting about how they can endure an entire flight without any form of entertainment. There's no distraction, no phone, no online in-flight entertainment, no books, no music, and some of the really sort of hardcore ones even forego snacks. And then they like film themselves doing this. And in my mind, I was just thinking, do you have a young child? Have you ever been on a flight with a young child? Like, that is raw dogging. And that is when you need every device and you just throw everything at the problem: food, snacks, candy, iPad, like take it. But I just thought it was kind of, maybe, I don't know if that's how we traveled in the 1980s, but even then we had books, but this is just a bit bizarre for
Wait,
me.
are you allowed? I mean, is what is not allowed? What is gadgets are not allowed? I get it, but are you allowed to talk to people?
The test is that you sit in your seat and you like are fixed and looking out the window for the
It's
entire
Vipassana on a flight, essentially, right? Got
of
it.
a sort, I
Don't talk to
suppose.
anyone. Don't make eye contact with the
No eye
air
contact.
stewards. Got
No
it.
music, don't read anything, don't watch anything. And I'm just like, then why am I on the flight? The
Yeah.
only reason I'm on the flight is because I get like four
Well,
or 5 hours to do this.
well, like if you're on the flight without children, I can see the value, and you'll just be like so happy that there's nobody, bugging you and asking you
But
a
that's the
hundred.
only time I can watch something, Manu, and I can like
There,
drink something.
Just
there are
enjoy the
two
peace and quiet.
there are two episodes here. One is trauma of flying with children, and there is the Julian Assange episode. That's right. On this.
Both of which involve planes and sea routes.
That's true. All right. That's episode 21 of the India Dialogue. Thank you so much for making it this far. Sometimes we start the episode thinking, oh, we'll go for 40 minutes. But at least I like as a listener, maybe you don't find it, but we find it so interesting that we get carried away and we go deep in the conversation. Thank you for listening. We're grateful that you continue to listen. Every now and then we get incredible feedback. We do discuss it, like the solutions point that was made today. We should discuss more solutions. We are always listening. We want to know more about what you think about our conversations. Please write to us at indiadialoguepodcast@gmail.com. You can find us on Twitter or X at TID_podcast, the India Dialogue TID_podcast, all on YouTube at India Dialogue Podcast channel. Mitali is at Mitali Live. Manu is at Manuraj1983. I am Ruchir_P. All of this on X.com or Twitter. Thank you again for listening, and we look forward to seeing you again next week.